Hello, welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a criminal defense and firearms lawyer, and this video is about how to file a Section 74 challenge. So, what is a Section 74 challenge? This is a provision of the Firearms Act that allows you to challenge the decision of either the Chief Firearms Officer or the registrar when they want to either refuse you a firearms license, authorization to transport, registration certificate, or certain other things, or if you already have one of those things and they want to revoke it, so they want to take it away. So this is a provision that allows for you to challenge those decisions fairly easily. It'll cost you less if you have a lawyer. It'll be much more navigable if you don't. Now, having said that, I always recommend that you go into these with a lawyer. These are legal processes. It's going to be difficult. You're not going to have a whole lot of experience. And just from a tactical perspective, it is a lot easier to have somebody else examining you on the stand than it is to go in and just talk. There's various ways that you can get tripped up, and you should be aware of that. The other side is going to be coming at this with a lawyer. They're going to have Crown Counsel there, likely very experienced Crown Counsel. So going at this alone is like going to a gunfight without bringing a gun. Now, I want to recognize that a lot of gun owners may not be in a situation where they can hire a lawyer. I do have a lot of sympathy for that, especially because if you're talking about somebody who's a subsistence hunter or the like, who needs their firearms in order to get by, that's going to be a very difficult ask if now they have to get money together for a lawyer. So I do recognize that, and that's part of what this guide is for, is I know some people are going to be stuck in a situation where they have no choice, where they don't have access to counsel. And so I hope that this video will be of assistance there, but I also hope it will be put a little bit of fear into some people when they look at what is involved, and this is a daunting process. You should be aware of what you're undertaking. So this all applies to only Section 74 hearings. And if you're looking at starting one of those, you probably have a notice from the Chief Firearms Officer or the registrar, which sets out the decision. It should also set out why they made the decision and what information they relied on. And it should include a copy of Sections 74 to 81 of the Firearms Act, which are the legislative provisions that allow for these hearings. So that should be included. Your first step is going to be to read those and read them carefully so that you understand the process at least a little bit. But this video does not apply at all if you're looking at a process initiated in another way. So if you're facing criminal charges and they're trying to bring a firearm prohibition as a result of a conviction, this doesn't apply. If they're bringing a Section 111 application in the criminal code, this also doesn't apply. And you'd know the difference because if they're sending you a form that says Section 111 at the top, we're in different territory there. Similarly, it doesn't apply where the police are relying on having seized your property and making an application to forfeit that property and have you placed under a firearm prohibition. So all of those are other ways you can lose your licenses and your guns, but they're not covered by this Section 74 process, and this video is not going to be helpful to you. You should also look at the date that this was posted, because legal information goes out of date, and it can go out of date either quickly or slowly. And unless you've done your research, you're not going to know which. So be aware that this could be very much out of date, and it also might not be applicable to your jurisdiction, because there's different provinces with different procedures on all of this. You're going to have the burden of doing your own research. I can't give you legal advice unless I'm your client. I don't know your personal circumstances. This is only a very broad overview. So with that out of the way, first thing, again, I recommend hiring a lawyer, but if you can't do that or you're not in a situation to do that, the first thing you're going to want to do is read over what they've sent you very carefully. And you're going to need to do this with as much of a clear head as you can. If you have a lawyer, show them the document. They'll help talk you through it. They'll help explain what all is going on and apply the legal standards to it. If you don't, you may want to find a neutral friend to have read over it and to get their assessment. I'd honestly recommend that you find somebody who maybe isn't super against guns, but somebody who isn't super keen on them either. You want sort of a neutral stance here. It's not as helpful to get somebody who is going to be saying, oh yeah, you did nothing wrong, and oh yeah, this is a total, travesty. You need somebody who's going to look at this with a fair and fresh eye, and somebody who's perhaps going to be coming at this from a somewhat skeptical perspective with respect to your rights, because you need that sort of sober second view. That's one of the harder jobs in terms of legal counsel, because you have to provide sort of the outside assessment. It's really easy when you're representing yourself, or where you can see the file through rose-colored glasses and you can believe that you've got a stronger case than maybe you do. So getting somebody else's impression on this is very much potentially helpful, and it can sometimes make more sense. It can tell you where you're weakest and what you're going to need to argue most strongly. Now, the next thing is, if you have a lawyer, they'll help you with the paperwork. But if you don't, that's going to be on you. And so the main thing that you have to remember is you've got a 30-day deadline, which starts when you receive your notice. So that's your starting point. Now, that's not a hard deadline. You can apply to the court to have them hear the matter even if you filed outside that deadline. You should treat it as though it's a hard deadline anyway, because you have to apply to the court to have them hear it outside of that. I will tell you, a lot of judges do not like these proceedings. The reason why is they don't deal with a whole lot of them. So if they're offered an opportunity to make this proceeding go away, they may take it. Don't give them that easy opportunity by filing late. So make sure you get your application in on time. Otherwise, you're starting from the position of being dead in the water, and you have to argue yourself out of that. So that's not a good place to be. Now, notice that the letter of revocation or refusal may specify a shorter period than 30 days for you to get rid of your guns. You should file before that time limit expires, whatever that is, because otherwise you may find that the police, for instance, might come to your door and kick your door down, which is never a fun experience. So get that in as soon as possible. You're going to want to start by getting some materials together. Make a copy of the letter that the Chief Firearms Officer sent you. You're probably going to have to give one of the copies to the court, and so you want to make sure you have a copy left for your own material. You're also going to want to bring a copy of your firearms license, any registration certificates that are relevant to it, and the reason why is because the forms they give you may ask for this information. You don't want to go to the courthouse, try to file the forms, and have them tell you, sorry, you can't do it. You need this information. So the next thing is go to your local provincial court webpage. You might be able to find a form for this there. Some provinces do, some provinces don't. If you can't find one there, phone your courthouse and ask them, do they have a form? Because they might. If they don't, and I've run into this circumstance where you're going to a courthouse and they just don't have a form that's recognized, you may actually need to create one. And so what I'd recommend is you can find one of the provinces that does have these forms online, and you can use that as a template. You'll have to change out the relevant information and so forth, but fundamentally what you need to include is your name, your date of birth, that this is a Section 74 reference, make sure that's on the page somewhere, and that why you're challenging this decision. They may bounce this, you may have to go at this a few times. So make sure to give yourself a little bit of time. My usual rule of thumb for filing documents is whenever possible, try to give myself about a week of lead time, and that varies based on how complex the document is, how many times I've done it. So if I'm filing something at the Court of Appeal, which has a little bit stickier rules, I make sure that I've got lots of time, just in case I've perhaps screwed something up in some fashion. And because if they say, we can't file this because it's bad in some fashion, I need time to fix that. You don't want to be in a situation where you're over the deadline because you screwed up on the documents in some fashion. So once you've filed this, you're going to want to ask the clerk of the court or whoever takes the filing whether they'll serve it on the chief firearms officer or the registrar. Sometimes they will. Some provinces, that's the expectation. They'll send it off. You're covered. In other places, not so much. So if that happens, you're going to have to figure out how to get that served, and you're going to want to get that served also within that deadline. So keep in mind, you may have to take those steps as well. Now, you're going to get a court date. You want to be very sure when you get this filed and when you're sort of planning this out, as that you know whether this is a date for the hearing or whether this is just a date to set a date for the hearing. Those are different things. You don't want to walk into a date thinking that you're just going to set a hearing date and find out that that's actually your hearing, everyone else is ready to go. Because there is the possibility that you'd walk in there and you'd say, I need more time. I'm not ready for a hearing. I'm not prepared. And the court would say, well, we're going ahead today. Keep in mind as well, for these hearings, if you don't show up, they're entitled to proceed in your absence. They can actually hold the hearing what's called ex parte, which means that it's a special procedure where there's actually a duty of fairness on the other side, that they have to present sort of both sides of the argument. However, it's going to be very hard for them to present both sides of the argument if you're not there to give your side. They just don't know it. So if you don't show up, or you get the date wrong or the like, they may run the hearing without you, and you might lose just because they don't have that information. So be aware of all of that. It's very important. Now, once you have a hearing date, you're going to need to start work on actually getting all of your evidence together. One of the big things is subpoenaing witnesses. You can go to the courthouse, you can ask them how you do this, they'll walk you through it. But you need to subpoena the witnesses that you want to have present. A subpoena is a legal document. It compels their attendance. So they have to be there. They can be punished for not being there if they're subpoenaed. But if you're at a hearing and suddenly your key witness doesn't show up for whatever reason, and you say, I need another day, we need to adjourn this, I need a chance to have this essential witness present. The court is going to ask you, did you subpoena this witness or did you just ask them nicely? And if your answer is, well, I just asked nicely, the court's not going to have a whole lot of patience for that. Make sure you subpoena your witnesses. Keep in mind, you might want some witnesses who maybe aren't your best friends. You know, you might want somebody at the chief firearms officer's office who you spoke to. If you don't subpoena them, they don't have to show up. So make sure that all of your witnesses are subpoenaed. You may also want to talk to the other lawyer because they may agree to subpoena some witnesses for you, especially at the chief firearms officer's office or the like. So if you need that, talk to them. They might be able to assist you with that, but be aware you may also just need to do this yourself. You're also going to want to start gathering any documents, any video, any audio, anything physical or tangible or the like that you might be relying on in your case. So you're going to be starting a file and putting all of this in there. Documents that you might want to have are anything that's relevant to the court, and particular to the standard, which is that you have the responsibility and discipline the law requires of gun owners. That's a high standard, but this might be, for instance, something to show that you are following gun safety regulations or gun safety principles. You might have things that say that you're a good person, that you don't get angry easily, this kind of thing. So it might be letters of reference. Although letters of reference are great, it is better if you have some people who can actually show up in court and attest to that, and importantly, can stand up to cross-examination on those points, because the court is likely to give more weight to evidence that has been sort of tested by cross-examination than they will just by a letter from somebody who's not before the court and where the other side hasn't had a chance to grill them. Now, for anything you want to bring, you're going to need to make 3 copies of it. And I would suggest making more than that. But 3 copies are what you'll want at the minimum, and that's in the hearing. You're going to need to have 1 copy for yourself, 1 copy that you'll give to the other side when you tender the evidence, and 1 copy that you give to the court. And that court copy is going to become an exhibit, which means you're not going to get it back. The reason why I mention this is that quite commonly you'll see people come in and they'll say, I've got some evidence and it's here on my cell phone. Well, in order to get that evidence in, you have to make it an exhibit. Do you want to give the court your cell phone? Probably not. That's worth hundreds of dollars, quite possibly. And it may also contain information that you just don't want to give the court, that you don't want to have potentially viewed by other people. All of your text messages will probably be on that. They may not be relevant, but now they're out of your control. They've been handed off. So don't do that. If it's video or audio files, copy them to a clean, blank USB key. That way you can give it to the court and not have to worry about it, and not have to worry about being out of pocket if you don't get it back. The other thing I recommend is that you be very diligent about backing things up and keeping them in a safe location. Several times I've had people tell me, I've got great evidence, it's going to prove my case, it's on my cell phone, I've got a recording, I've got text messages, I've got call logs, I've got whatever. And then somebody steals their phone, or it falls out of their pocket and they back over it, or it ends up in a toilet. And if that's the only copy you've got, your case just got a lot worse. So I always recommend that people back up and make copies and keep them in separate places of any of these important documents. If your house burns down, are you going to have a copy? Think about these kinds of things. I know it may sound a little paranoid, but it's always better to be sure. And as I said, I've seen it way too often where people have everything they need on a cell phone, and it meets with some bad end. Evidence you have might also be relevant if it undermines the reason for the chief firearms officer making their decision. And that's either because it contradicts something that they think, or because it undermines some assumption they've made. So as an example, your chief firearms officer might have decided that you are not suitable for having a license, and in part, they might have called one of your previous bosses, and your previous boss says you're an angry guy, you can't be trusted, you're erratic, you're an alcoholic, you're whatever they want to say. But you might have information that says, I left my previous workplace because I filed a workplace safety complaint, and then they were harassing me, they started cutting my hours, and that's why I left. And so the assumption the chief firearms officer has made there is that this information that was provided by your old boss was provided in good faith by somebody who doesn't really have much skin in the game, that they're just providing an honest assessment of you. But if you have counter evidence that shows that maybe that person is coming to provide this statement because they don't like you, because they want to harm you, that can be helpful. It undermines that bit of evidence that they're relying on. Similarly, in some cases, the chief firearms officer might be relying on evidence that is false. I've seen, for instance, that they rely on, you were charged with an offense and we think you did those things. But you might have been acquitted at trial. And you might even have been acquitted at trial with a statement from the judge that is very much in your favor. The judge might have said, I believe you, I don't believe the other side, and so therefore I'm not going to convict. That information would be really helpful to have, because then you can show that the chief firearms officer has relied, and again, probably not in bad faith. It's going to be rare that you're actually suggesting that the chief firearms officer was engaged in some sort of bad faith action. But in that case, you might be able to show that they relied inadvertently on information that's just not good. So the transcript of that previous decision might be a relevant piece of information. Again, these are just examples. Your situation is going to be unique. You're going to have to decide for yourself what you need to bring. The next thing you've got to consider, and you're going to have to do a lot of work on this, is reviewing the law. Because you're going to be held to the law even if you don't know it. The court is bound by the law, and So what you're going to probably need to do is rely on services like Canly, which will allow you to look up prior decisions, and Canly is free. But it's also not the most powerful. So you may want to call the local library or local law library, which will be located at the courthouse. And in particular, you should look maybe to larger centers, because some of them may have Westlaw or Quick Law available for use by people who are coming in. If that is the case, you may want to consider taking some time and making those searches. Westlaw and Quick Law are expensive, so you need to be aware of that. If you're not able to get access via some other source, it's going to be costly if you want to look at those. You may you may or may not choose to rely on just Canly, but keep in mind, case law sets the rules of the game. So if you don't know what cases have decided before you, it's like sitting down at the casino to play a new card game with money on the line and never bothering to figure out the rules. You don't know if an ace is high, you don't know if an ace is low, you don't know what patterns of cards you need. You're gonna lose your shirt. So when you're looking at case law, you also need to have some understanding of precedent. Now, in terms of what precedent means, the courts want to have consistency between cases. They want to ensure that one case is decided like the next case, which is decided like the case after it. So the way they do that is by relying on decisions that were previously made to set standards. Now, there's two sort of main categories of case law. The first category is binding case law. And binding case law, the court cannot reject. It must follow it if that case can't be distinguished, and I'll explain what that means in a moment. But binding case law will include any decision from a higher level of court. So if you're in provincial court and you have a case from the Court of Appeal in the same jurisdiction, then that's going to be binding on the court that you're in. Similarly, the Supreme Court is binding on any court that isn't the Supreme Court of Canada. So those are sort of your sources of binding precedent. You may also have case law that is what we call persuasive. Persuasive case law, the court is not required to follow, but they're going to be inclined to follow it if they don't have a reason to go another way. So that includes decisions from the same level of court or a lower level of court in the same jurisdiction, as well as cases that have come from not the Supreme Court, but outside the jurisdiction. So that's your main binding versus persuasive. On a persuasive case, you can argue that the case is wrong for some reason. But again, you're going to want to have reasons why. And that means you're going to need to understand the case at a fairly high level in order to be able to convince the court as to why that other case is wrong. The court's not going to want to reject a prior case just because it's going to make you lose or just because it's going to be harmful. You're going to need a better reason than that. In terms of binding case law, there's not a whole lot you can do with that if it's against you. This is where we get into distinguishing, because cases, they'll set out legal principles, and so long as you're within those legal principles of a binding decision, you're stuck. But distinguishing is where you say, this case applies in a particular situation, and we're outside that situation. Our facts here are different in a way that says that you shouldn't apply that previous case. So what you're essentially saying is that that case doesn't apply to our personal, the particular circumstances that are before the court. And so that's the only way you can deal with bad binding case law. And the court may or may not agree that it's different circumstances, but that's the only argument you can make. The next thing you need to be aware of is that the relevant time that applies is the date of the hearing. And what I mean by the relevant time is when the court is making that determination of whether or not you are a person who should have guns or should have an authorization to transport or whatever it is, they're making that decision based on the person who's there in court that day. So things that happen in between the initial decision and the ultimate hearing are relevant. They can change the game. They can change the game in a big way. So as an example of things that are positive, the chief firearms officer might have said, we think you're depressed, and so we want to take your guns away because we're concerned that you might use them to harm yourself. In the meantime, you might have gone to a counselor and got some sort of treatment, and so you might have a statement from the counselor that says he's really put some work in, he's gotten better, he's no longer in a position where he's a danger to himself. And that's a way that you can overturn or overcome that onus, is that you can show that the decision of the chief firearms officer might have been the right decision at the time, but that things have changed. So, anger management, drug treatment, depression counseling, all of these things can be helpful. Keep in mind, this is a two-edged sword. So if they're saying we want to take your guns away because you're a violent person and you have a road rage incident in between, you and this, and police are called, there's a report, and of course the chief firearms officer is going to find out about this police-involved incident, that's going to look very, very bad. And the reason why that's going to look even worse is that at this point, there's a court proceeding going on, and you still had this problem. So if I was a Crown prosecutor or a Crown trying to argue that you shouldn't be able to have a firearms license, I'd be putting a lot of weight on that, saying, you knew that you were under scrutiny. You knew that you needed to be on your best behavior, and this is your best behavior? So that means you need to be very careful about what you do, what you say, what actions you take in between, because they can sink you, or they may make your case. So let's talk about what to do on the day of hearing. The first thing, and this will sound obvious, but I mention it because I've seen people make this mistake, is you need to bring your evidence. It's not going to do you any good if it's in your car. It's not going to do you any good if it's at your house. You need to have it there with you for the hearing. So make sure you've brought it. The court may not grant you an adjournment if you need to go back to the house to get it. They will probably take a very dim view of that. They're going to be wondering, what is this guy doing? Even if it's just in your car and you have to go run out and get it, you've already made a bad impression with the judge. So don't do that. Make sure you've got all the case law that you want to rely on, that you've got everything you need to go ahead. Make sure that when the judge asks you, are you ready to proceed today? You can stand up and say, yes, sir, or yes, your honor. The next thing is clothing. Now, we've all seen the statue of Lady Justice with the blindfold. I will tell you, Lady Justice peeks, and she peeks all the time. In theory, the idea is that justice isn't going to judge you based on how you look or anything along those lines. But in practice, judges and the court process it's all actual people, and actual people are fallible. Judges expect and deserve your respect. And one of the ways that they'll judge that is whether or not you're coming in dressed appropriately, dressed in a fashion that shows that you're taking this seriously and that you respect the process. Now, you might think that always means a suit and a tie. And I'll tell you, I've got a suit and tie, so I always wear them if I'm in court. And if you have a suit and tie, absolutely throw them on. That's the right thing to do if you've got one. But if you don't, I'm not going to suggest that you go and buy one for the occasion, and I'm certainly not going to suggest that you borrow one for the occasion. What you should do is dress nicely, the way you would for, a family member's, a significant event, possibly a funeral, although maybe a little, not necessarily as somber, or a job interview. Think that sort of level. So button-down shirt, pants, no t-shirts. I would say avoid revealing clothing, because some judges may judge you harshly if you're dressed in that fashion. Avoid t-shirts or clothing with slogans on it. And especially do not wear anything that has slogans or images that the judge is going to take offense to or is going to look down on you for. So some examples, and all of these examples are things I have seen in courthouses. So One is Sons of Anarchy gear. I love the show. Great show. But it has a distinct look of motorcycle club gear. And your judge may not necessarily be aware that this is not actual motorcycle club gear, this is just a show. And you don't want to be in a situation of having to explain that, but I'll tell you, the judge probably isn't going to ask. If that's what they think, they're just going to make that assumption and you won't hear about it. But it will color their decisions. Similarly, motorcycle club gear. I know not all clubs are 1%ers. There's a reason for the 1%er term. But if you're there wearing motorcycle gear, your judge may not be aware of where that particular club falls in. And certainly, if your motorcycle gear is 1%er gear, you wouldn't want to advertise that to the court. You may get judged quite badly if you're going in wearing that sort of gear. One that I think is fairly ridiculous, but I'm going to mention it anyway because I've seen it on multiple occasions, is people going in wearing wings. I don't know why this was ever thought of as a thing, but I've seen people going in wearing, little dragonfly wings or angel wings or the like. Don't do that. Nothing strange or outlandish. Keep it sort of within a standard deviation of conventional behavior. And I know that, if your lifestyle maybe isn't conventional, that may not be sort of how you feel most comfortable. But you don't want to make the judge uncomfortable. You don't want to project an image that is going to be used against you. You want to be decided on the facts and the law, not on how you look. Similarly, you get brands that are, Crooks and Castles, Cocaine and Caviar, these kinds of brands. Do you really want to be walking into court with a big thing that says Crooks on it? If you're having trouble with that question, the answer is no. No, you do not. I've also seen people walk in with big marijuana leaf shirts. And it's legal now, so it's not as bad as when people did this when it was illegal, but it's still not a great idea. The court isn't necessarily going to decide that you are, a massive drug user if you're wearing a marijuana leaf shirt and that you can't have a gun, but it's also not going to help. So skip all of that. Similarly, sometimes people think they're clever and they bring in sort of subtle references. So somebody coming in with Jamaican flag imagery. And great, but you need to be aware that while some judges may not be sort of up on imagery and up on, if you're walking in with a big RA on your shirt, red shirt with RA written on it, some judges might not be aware of that. But some judges will. And so you might think that your reference is really clever and really subtle, and the judge may pick up on it anyway. So you need to assume that the judge might be confused by a sort of innocuous symbol that could be mistaken, or might pick up on a signal that you think is, clever and understated. The best approach is no writing, no symbols of any sort. It can't be misinterpreted. It can't be used against you. Again, the ideal of, the blindfolded Lady Justice, that would be a great place to be. But your judge is going to be an actual real person. They're going to make decisions based on what they see, and these may not even be conscious decisions. It's going to weigh in the back of somebody's mind, potentially. So avoid anything like that. Your demeanor matters, and it matters a lot. So remain calm, remain polite. You are being judged. They are trying to decide if you are the sort of person who has the character that they want in a gun owner. And your judge may think that's a very narrow category. Your judge might be pretty strongly anti-gun and think that only the best people should have them. You want to be in that category. So you also need to remember that this applies to everyone in the process. Don't go and pick a fight with the opposing counsel. Don't pick a fight with the chief firearms officer if they're there. Be calm, be courteous, be polite. The chief firearms officer can very well get up on the stand and say, I gave this guy this notice of refusal, and I'm even more convinced that he shouldn't have guns because when I got here, he came up, he was in my face, he was swearing, he was pointing his finger, he was all of these things. You'll regret having done that in a real hurry if the chief firearms officer is just, now getting up and testifying to that. Similarly, you need to be aware that they don't generally have anything out. They're not out to get you. They're just doing their job. They're just going through the process. They're trying to make the best decisions they can. You don't want to give them a reason to dislike you personally, because that's going to give them more reason to actually put work in, more reason to want to ensure that you never get your license, get whatever it is you want. The other thing I will caution you about is the clerk. The clerk of the court, basically you should consider them as outranking everybody. When court breaks, they may get to go into the back and have conversations with the judge that you don't hear. And so if you've mouthed off to the clerk of the court, there is the possibility that that may get to the judge. Similarly, nobody will view it nicely if you are hostile or rude to the clerk. Think of this as, you walk up to a bear and the cubs and you just punt a bear cub. It's going to be a bad day. The clerk of the court is the person, if you have to be nice to anybody in court, and you should be nice to everybody in court, but if you have to pick one, the clerk is a not bad choice. So you need to be aware of that. Sometimes people think that the clerk is, just a functionary. They have a tremendous amount of power in actual practice. Don't make that mistake. You also need to be aware that the other side may try to make you angry. And they can do that. When you're getting up on the stand, they're going to have an opportunity to ask you questions. And so they may ask you questions in tones that might be disrespectful. They might ask you questions you don't want to answer. They might be insulting. And they're not going to come out and just insult you, but they might suggest things about you that are not flattering. And so it's really easy to get upset and get angry. And once you do that, you're going to start making bad decisions. But also, the judge is going to look at this and say, he's supposed to be on his best behavior today. And look at him, he can't control his temper. I don't think this person should have a gun. So don't let them goad you. If you need to, take a deep breath. You just need to remain calm, remain polite. I will say it looks amazing to the court if you have faced a brutal and, anger-raising cross-examination and kept your cool, but it is devastating to your case if you flip out. So this is more important than perhaps you think, and it's, in my view, essential. This should also go without saying, but do not lie in court for any reason. Lots of people I've seen have thought they were smart enough to get away with it, and I will tell you that it doesn't work out. Lawyers get described as sharks, and to the extent that we're running with that analogy, a lie is blood in the water. So I've had situations where the opposing side has a witness, and that witness is telling some horrible lie about my client. And the client is probably upset. They're angry. They want me to intervene. They want me to stop this somehow. Meanwhile, I'm sitting there. I don't want this to stop. I've got a big smile on my face because I know that this lie that's just been told has given me the keys to the case. Because by the time I'm done with this witness, the court is not going to put any weight on them whatsoever. And from the perspective of a lawyer, this is a fun process. You get to use your mind, you get to, you're engaged in a challenge. But from the perspective of the person on the receiving end, this is not a fun process. And it's necessary when you're a lawyer. You have to engage with this. But you'll see the other side when you're catching them in the lie, and when you're doing so effectively. You'll see them get stressed, you'll see them get anxious, you'll see them get angry, all of these things. Sometimes people break down in tears. It's a very unpleasant situation. It's one that I recommend that if you can avoid it, that you avoid it at all costs. It's humiliating. The way to avoid it is you tell the scrupulous, honest truth. And you do that even when you think you're revealing information that's bad. Presumably, if you've brought this reference hearing, you think you're a person who should have firearms, should have an authorization to transport, should have whatever it is you're asking for. But you need to recognize that, of course, we're all complete, whole people, and we all have wrinkles. We all have bad things. I've just told you I've enjoyed it when I've been in, the sort of driver's seat of one of these cross-examinations. That's maybe not the best thing, but you want to admit the bad things because it's so much better than being caught in a lie about them. And I will tell you that one of the most persuasive kinds of witnesses is a witness who can get up and freely, honestly admit the bad things without sort of covering for them, without hedging, without anything. A clear, concise, honest answer goes a long way. If the court thinks you're lying, I will tell you that they are not going to put a whole lot of weight on your evidence. And if they think that you've been caught on a lie on one thing, obviously they're going to be wondering what else you will have lied on. So once you're caught in a lie on something, it casts everything into doubt. And if the court thinks you're a liar, if they think you're the sort of person who's willing to get up and tell a false story in court under oath in order to get a firearms license or to hold on to their firearms license, I can pretty much guarantee they're going to think that you are not the sort of person who should have one. You also need to be aware that if you lie in court, you can potentially be charged and potentially convicted for perjury. Now, a perjury conviction comes with a lengthy possible maximum sentence, but it also comes with a further wrinkle that maybe you may not have thought about if this is something that you're thinking about. And that is that if you get convicted for perjury, you should expect to get that entry on your criminal record. And that entry is death to your credibility in any further dealings with the court. So if you go in and you say, I bought this car from this salesman, and, it turns out the engine is blown, and, this guy ripped me off, and the salesman comes in and says, I told him the engine was bad, I told him this and that. They're going to look at that perjury conviction, and the court is going to know that you're a person who lies in court under oath. It essentially makes it very difficult for you to be able to rely on the protections of the court going forward in future. That is going to be a very heavy weight if you ever need the court. So I would say that a perjury conviction is one of the worst things you can have on your record. Do not risk it. I would personally rather lose all of my firearms than get a perjury charge. It's not even close. Not even a little close. So don't lie in court. I cannot emphasize that enough. The next point is not as serious, but it is still serious. Don't attack the other side's lawyer. Attack their arguments. So if their argument is bad, you can say that. You can say, here's where their argument is bad. But the court is going to take a very dim view if you say, if you throw insults towards them, if you're even disrespectful towards them. I have seen somebody in court, not my client, but somebody who was there representing themselves, and they were being very hostile and snarky to the judge. And the judge sat there and took it. And then the Crown prosecutor tried to help them out, tried to basically weigh in to provide them with a little bit of help. And they insulted that Crown prosecutor, and they snatched a document right out of the Crown's hand. And that's when the judge stood up and had the person carted out the back door, which means they're going into cells. So you need to be aware that it's not a game you're going to win. And if you're acting like this, again, it weighs on your character, which is the whole subject that they're assessing here. So don't do it. And as I've said before, the clerk is sacred. Do not abuse the clerk for any reason, under any circumstances. It's a guaranteed way to shoot yourself in the foot. Now, in terms of more practical information, you need to know the difference between an examination in chief and a cross-examination. And the reason why is because these things have different rules. So an examination in chief applies to when you call a witness or when the other side calls their own witness. This is what we call the examination in chief. In that exam, or at that questioning, they can't ask what are called leading questions. Now, I'll give a little caveat to that. The court will allow probably some leading questions where they don't matter. And so often you'll see a lawyer start off with some leading questions like, your name is so-and-so, you work here, and so forth. Nobody cares what their name is or what their work is, so we allow that just to save time. But when you start getting to the actual subject matter, when you're getting to the actual questions you want the court to rely on, you cannot lead the witness in an examination in chief. So what ends up happening is you'll say things like, now I want to take you back to the events of this day. Do you remember what happened on that day? And, you'll probably get a yes. And, can you tell us what happened? And you may need to ask some follow-up to sort of narrow it down. And you're going to be asking a lot of questions, or the other side will be asking a lot of questions that are like, and then what happened? Or something like, what was his demeanor during this event? That kind of question where it doesn't suggest one answer over another. So if you're asking a yes or no question, you can ask those questions sometimes in an examination in chief, but it can't be one where you're suggesting one way or the other. And if you do that, the other side will object, and the court may assign lower weight to an answer. That may be no weight. So if the court thinks that you've got this witness and it's your witness, but you're just feeding them the story, they're not going to put a whole lot of weight on that. They want to hear the witness's side of things spontaneously generated first. Now, after the examination in chief, the other side, so whichever side didn't call the witness, gets to conduct cross-examination. And cross-examination has much fewer rules. You're allowed to ask leading questions. In fact, you're encouraged to ask leading questions. You can ask questions that outright suggest things. So you can say things like, isn't it the case that you stole the car? Totally not an appropriate question on examination in chief, but on cross-examination, you may want to ask that question. And in fact, you may be required to ask that question because there's a legal principle called the rule in Brown and Dunn. The court may not hold you to it as strictly as a self-represented accused, but if you have or a self-represented individual, but if you have an alternate view of the case or a view of the facts, you're expected to put that to the witness to let them respond. So even if they just say, no, that's not true, you have to give them the opportunity to respond to that. So if you think, for instance, that, they've brought in a witness who says that you threw the first punch in a bar fight, you may have to tell that witness, isn't it the case that the other guy threw the first punch? Even if you know, because of what he's already said, that he's going to say no, he still has to have that opportunity to respond to your version of things. So entire books are written on how to conduct cross-examination. I do not have the time to teach you how to do this properly. If this is something that you are looking at, you may want to go to a law library and pick up a book on cross-examination. There's a large number of, I can't say I know it all. I can tell you that I have seen very senior counsel conduct cross-examinations where I'm just going, I'm taking notes. There's a lot to learn. There's art to it. There's science to it. It's not easy. After the cross-examination, the side that originally called the witness will get an opportunity to, if they want, engage in what's called redirect. And redirect is you get another chance to ask them some questions, but you're not able to ask them just any old thing. This is not the place to ask a question that you forgot to ask before. If you did that, you screwed up. You missed your chance. But what this is for is that you may have questions that you need to ask to clarify some of the things that came up on cross-examination, or on cross-examination, a witness that might have gone down a path you didn't anticipate, and now you need to explore that a bit more. Often, redirect is a very bad place often to try to fix bad evidence, unless it's a situation, and this is where redirect really comes in handy, where essentially the answers and the questions are misleading. So for instance, you might have a witness up on the stand and he's a very important witness for you. You need him to be credible and you need him to be taken seriously by the court. And the other side says, isn't it the case that late at night on this particular day, you were stopped by the police because you had been seen running in the street, screaming in the middle of the night? And he says, yes, but, and they say, thank you, no more questions, and sit down. On redirect, you might know what the details about that are. So you might ask, can you tell us why you were running and screaming on that night? Because it might be that the person, had disturbed a wasp's nest and is running and screaming because they're being stung by wasps. And so now the court, at the end of the cross-examination, that witness sounded like a crazy person. But now the court understands that it's just a temporary circumstance. This is an example of an effective place where you'd want to use a redirect. Again, I can't really give you the full details on sort of how to conduct all of this. There are volumes and volumes on this, and I recommend doing some reading if you're going to be in a situation like this. Last point for in the hearing is that you need to remember everything is recorded, and that even if it's clear that you're going to lose, you need to get all of your evidence out. You need to ask every question that you want to have heard, because you might decide you want to appeal this. And an appeal is going to be decided by virtue of what's in the evidence, what is on the record. And if you didn't bring it out in court, the appeals court can't look at it. So even if you think you're sunk, you're done, you may still want to continue conducting this. And it's very important sometimes to make sure to put things on the record. This applies especially if you're objecting to some evidence that's coming in or the like, because if you don't object to it at the time, you probably can't object to it on appeal. So you need to not only be thinking of the case you're fighting now, but also the case that you might be fighting next time. So be aware of that. It's something that this is one that's easy for lawyers to screw up, but you're not going to want to fall into that trap. It can be a very unpleasant situation or an unpleasant feeling if you're going and you want to appeal this and you realize that you just haven't laid the groundwork for your appeal. So be aware of that. Other things that you're going to want to do if you're thinking of bringing one of these challenges. First, check your local rules of court, because these are provincial court hearings, so they're going to be governed by whatever your provincial court rules are. They may tell you things that you can't do, things that you must do, things that you may do. You need to know that. You also should check in particular as to whether provincial court allows for awards of costs. Awards of costs are rare for firearms matters. However, they can be ordered. And so you need to know if there's the possibility that the other side might ask for costs if you lose, which might mean that not only have you lost, but now you have to pay money. Check to see if costs are available. Are they mandatory? Are they discretionary? It's very important that before you go into a courtroom that you know how much you have to lose. And next, this doesn't just apply to you, but it's a consideration. A lot of times people are saying, I want to bring one of these applications because I want to help other gun owners. And so you need to consider the risk. If you bring this application on your own, what is the precedent going to be? Is it going to help or hurt other people? And you need to be aware that, if you're doing it to set a principle or to set a precedent, you almost certainly want a lawyer present. You almost certainly want a lawyer to help you out, because you may be changing the law for the worse for other people. So if that's your consideration, is you want to help other people, be aware of that risk as well. Sometimes people want to bring a Section 74 review where they don't have a clear refusal or revocation. And in those cases, I would suggest that you almost certainly need a lawyer. It's going to be a lot harder. You're going to have to make arguments that are a lot more difficult, that are a lot more unusual. And there's a lot of potential that you can set bad law here. So be mindful of that as well. This somewhat applies to the circumstance that a lot of us are currently in. If you saw my last video, the notice that went out, or rather the letter that doesn't even claim to be a notice, or at least doesn't claim to be a notice of revocation. This is a tough, I can't tell you whether you should or shouldn't bring a review in this, but you need to be aware of the possibility of risk, and the possibility of risk that applies not just to you, but to other people. That may be something that you care about, it may not, but it's something you should be aware of. So that one is a question that is still very difficult, even for lawyers with a lot of experience in this field. They've created a very difficult situation for us to determine how to navigate. So that ultimately is going to be a question you have to decide. Once again, I absolutely recommend that you have a lawyer if you're looking to bring one of these. I do, as I said before, recognize that some people won't be able to. And that's a tragedy of the current world that we live in, is that you have people who are not necessarily able to access the courts with the full strength behind them that they should. But you need to be aware that just watching this video is not going to make you an expert. It's not enough. It's not nearly enough to equip you the way you need to go in and equipped. I have seen self-represented individuals make arguments that I considered very good. But it's hard. I can tell from reading their work and from seeing what they've done that they put quite possibly hundreds of hours into it. Because not only did they have to learn the fundamental law around firearms hearings, but they also had to learn, the law in general. They had to learn very specific law. It's a lot of work. So there is no substitute for legal counsel there in your corner. And again, watching this video, this is general information, but you're not getting specific legal advice tailored to your situation. You're not getting what a lawyer would provide to you if you were there in their office. So there is no substitute for that. And the last warning, which I'll reiterate, which I gave at the start, this will be becoming obsolete from the moment I post it. Case law changes all the time, and sometimes case law changes very slowly. You may have areas of the law that are they've been stable, they've been concrete for a long time. But then you can have a decision from a higher level of court that suddenly flips things on its head, changes the rules. Everybody's got to adapt. And if one of those has happened between this video and you going into a hearing and you don't know about it, you might be going in relying on information that is no longer correct. You have that responsibility to look it up, to know what you're looking at. And so this is very much a caution about bringing one of these applications on your own. But if you do, you should be armed with at least some information. And it's very much a sad commentary, I think, on the state that many gun owners find themselves in. Thank you for watching, and I hope this has been informative. If you like this content, please like and subscribe. It'll help me make more videos. And I can tell you that the next video I have, I don't want to give away too much, but it should be fairly interesting. So if you like this one, I think you're going to want to see it. If you have any questions or comments, please leave them in the comments below. The other thing is my wife and I are getting a new puppy. It's coming on Thursday. We still don't have a name. I'm hopefully putting up a picture right about now. It's fairly low res, but this is the best picture I've got at the moment. But if you have any thoughts for names, I'd love to see those in the comments as well. Thank you, and until next time.